Let's get started. Thank you everyone for joining. I apologize. I'm going to have my video off today. I'm doing a little bit of juggling on this end with Zoom classes and whatnot. So I've asked Dawn if she can help kind of guide us through the agenda a little bit, since I may be pulled in a couple of directions this morning, but I think we're ready to get started. So should we do roll call first?
Sure.
Dwan, should we do the Zoom housekeeping first, or?
Oh, yes. Kim, would you mind doing the housekeeping?
Yeah, I'll do it. Okay. Excuse me. Welcome committee members, liaisons, and members of the public to the Legal Services Trust Fund Rules Committee meeting. We will begin shortly. We are using Zoom with the goal to foster a more inclusive environment and effective meeting. If you would like to make a comment during the meeting, please type "I have a comment" or "I have a question" in the chat, and the message will be sent to the host. Alternatively, you can also use the raise hand feature. In efforts of transparency for those joining this meeting, public meeting, whether by phone or by Zoom, we request that you refrain from having side conversations on the chat about the content of the meeting. Again, the chat is a feature utilized to simply as a tool for you to virtually indicate you would like to speak in order to help the chair facilitate the meeting. Also, going forward, we are recording this meeting and it will be posted on the State Bar website at a later date. A friendly reminder, this is a video conference meeting and please be aware of the surroundings behind you.
Thank you, Kim.
Okay.
Oh, sorry, go ahead.
No, go ahead. I'm done.
No, I'm sorry. I thought you said, I apologize. I thought you were finished. Go ahead.
I was just going to do the troubleshooting tips real quick.
Okay.
Tips for those joining Zoom by computer: when on mute, holding the space bar down will temporarily unmute you. If you're on the phone and dial into the meeting, please make sure your computer microphone is on mute to avoid any audio feedback. And while joining audio via computer, it is highly recommended that if an individual loses audio, they can call in separately using the Zoom conference number. I'm finished.
Okay, thank you, Kim. So I'll do roll call now. Amin Al-Saraf.
Present.
Great. Corey Friedman. She won't be able to join us today. Zahira Mann.
Here.
Jim Meeker.
Here.
Kim Savage.
Here.
Judge Seligman.
Here.
And I also see Rich Rhinus, who's a member of the commission, but is not officially on the rules committee. He is, however, on the one of the working groups that's presenting today. Rich,
here.
Are you still there?
Yes, ma'am.
Rich Rhinus, great. And are there any other commissioners that are on the commission but not on the rules committee that are joining us today? I'll go to our liaisons. We have a new Board of Trustee liaison. Debbie Manning, as you may have heard, has stepped down. In her place, we have Christine Gonan, which I don't believe she's on the phone right now. Chris Iglesias, I don't see him either. Bonnie Huff. Selena Copeland.
I'm present.
Great. I'll do State Bar staff. Elizabeth Holm.
Present.
Erica Carroll.
Here.
Crystal Bundang.
Here.
Brady Dewar.
Here.
Dan Pasamanek.
Here.
Are there any members of the public who would like to introduce yourself at this time?
It's a couple. They need to unmute their microphone.
Could you do that, Kim? Unmute their microphones if they would like to see if they want to introduce themselves.
Zolin Fu, Betzedek, VP of Legal Services.
Kim, Vicky, are you unmuting everybody else so they can introduce themselves?
Hi,
Yeah.
this is Jennifer Kelleher from the Law Foundation of Silicon Valley.
Hi, Jennifer.
And Jennifer, may I ask what your position is at LFSV?
Yes, I am the Chief Program Officer.
Thank you.
Hi, Lauren Klein from LAC is here.
Hi, Lauren.
Zach Newman from LAC is also here.
Hi,
Hi, John
Zach.
Effelt, Managing Attorney with Public Advocates is here.
Hi, John.
Hello.
Hi, Dana Marquez Richardson, Program Manager for One Justice is here.
Hi, Dana. Welcome. Are there any other members that would like to introduce yourself?
Hi,
Okay, we
Juan.
can
It's
move
Claire
on to-
Sola. Can you hear me?
Hi, Claire.
Oh,
Hi,
yes. Hi,
Claire.
Claire. Welcome.
Hi, everybody. Good to see you all. Claire Solat, Legal Services Funders Network and Bigglesworth Family Foundation.
Great.
Good morning.
Okay.
This is Deborah
Did we
Harris.
get everybody? Oh, hi, Deborah.
How are you? I'm Director of Development for Public Advocates, just taking notes today for our team.
Okay. Thank you. Thank you, Debbie. Okay, I think, shall we move? We have quorum. Shall we move into the first agenda item?
Yes, thank you everyone for joining. Do we want to take public comment now, or do we want to?
Yeah, we can open it up for public comments now, or if you'd like, you can wait until we discuss the particular topic. If that we're flexible. So if you'd like to make public comments right now, you can indicate it in the chat box, and then we'll unmute you.
I see one chat.
Yes, I see Fu from Bethzetic. Can she be unmuted, please?
Can you hear me?
Yes.
Okay.
Yes.
Sorry, we weren't able to submit the written comment in time, so we have prepared written comment that we can send later, but I will just read from the written comments. Thank you for the opportunity to provide comments on the Rule Committee's proposed changes. Bethzetic would like the committee to consider the following: defining indigency by area median income, not utilizing LSC rules on income exclusions, and preserving a higher income threshold for organizations where the principal means of delivering legal services is through free services of attorneys in private practice without compensation, which I will later refer to as pro bono programs, or in the alternative, providing for increased funding allocation for pro bono programs. On the issue of defining indigency, we are aware that the proposal currently is to define indigency still by FPL, but increasing to 200% FPL. Bethzetic serves a low-income community in Los Angeles County, which is a mostly urban area where the cost of living is very high. More families are falling into poverty and homelessness at an alarming rate. The current proposal, while is a step in a worthy direction, it does not take into account the reality of disparity between urban and rural areas in the state of California. A family of 4 earning 200% FPL, which is $4,366.67 a month, may be able to actually live in a single family home in a rural area, but in Los Angeles, they will struggle financially, where the average rent for even a 2-bedroom apartment is, as of last year, $2,257, which is more than 51% of this family's income. Defining indigency by AMI, which is the way we define indigency for pro bono programs currently already, will mostly more closely reflect the economic realities in the different communities in the state. On the issue of whether or not to utilize LSC income.
I'm sorry, Lynn, you cut out. I'm not sure.
Sorry, which part did I leave off on?
I'm sorry, you cut out. It might have been just my internet, but I
Right.
didn't hear that last couple sentences.
I just said that
From
defining
by AMI.
indigency by AMI more closely
But it might
reflects the economic realities in the different communities in our state. And Duan, I can send you the written comments afterwards if it's better for recording into the minutes.
Oh yeah, that would be great.
Okay.
And we can forward it on definitely to the committee as well. Thank you.
Thank you. And on the issue of utilizing LSC income exclusion rules, for at least the non-LSC programs like ours, screening financial eligibility by applying these rules is administratively burdensome and would likely lead to inadvertent exclusion of otherwise eligible clients. Like many legal aid organizations, BEDSEDEC derives its funding from a variety of sources, many of which impose their own financial eligibility requirements. At intake, staff will need to ask a potential client the most onerous and comprehensive set of possible eligibility questions to determine what funding source, if any, can be applied towards serving that individual. LSC income exclusion rules are detailed, onerous, and unfamiliar to our staff, and would require significant training, retraining, and monitoring to properly implement. At the same time, potential clients are often in crisis already when they reach us and already overwhelmed with the time and effort required to apply to various agencies and organizations for assistance. To require them to answer these detailed and often very personally invasive questions about their income sources and personal circumstances would create additional barriers to accessing our services. Those who do not feel comfortable answering all these questions may be inadvertently screened out from eligibility. To the extent that the income exclusion rules are meant to help particularly vulnerable populations such as survivors of domestic violence, the same can be achieved in other ways, such as establishing higher income thresholds for a person fitting in these categories. And then finally, on the issue of higher income threshold or funding allocations for pro bono programs, we are BEDSEDEC, one of the pro bono programs whose principal means of delivering legal services is through pro bono attorneys in private practice, and thereby qualifies currently for using a higher income threshold to define eligible indigent persons. Our ability to engage significant pro bono resources to serve more clients in need is not cost-free. We continuously invest significant monetary resources, time, and effort to build partnerships with the private bar and recruit, train, and support pro bono volunteers in every aspect of our work. To allow us to continue to engage pro bono resources and to incentivize other trust fund grantees to increase pro bono engagement, thereby serving the goal of expanding legal aid services to more people in need, the committee should consider either maintaining a higher income eligibility threshold for pro bono programs, no matter how you end up defining that indigency, or more directly, provide for a way to increase in funding allocations for pro bono programs. Thank you for your consideration.
Thank you very much for your comment. Should we move into the next agenda item? I see there's a couple of comments in the chat about comments perhaps later on in the discussion, so we can get to those. Unless there are any other, is there any other public comment to be made now? Okay. Duan, we're having some difficulty hearing you or seeing you now, actually, as well.
Signal is kind of fussy and we sometimes lose her.
Yeah.
Dan, did you want to appoint another state bar staffer just in case we lose her?
Hi, this is good morning, everyone. Dawn's internet is frozen, so Amin, what is the next item that we want to move to?
Yeah, I think let's move to the next agenda item, which is the minutes from the last meeting.
I'm sorry, I had my mute on. Yeah, we've got the approval of meeting summary and action items from the March 6th, 2020 meeting.
Is there any
Do we have
discussion?
any?
I'm sorry, I mean,
Go ahead, Elizabeth.
is there any amendments or revisions to the minutes?
I'm not a voting member of this committee, but the minutes seem to reflect what happened. I don't see any errors.
Okay.
And I don't have any comments either. So unless anybody else does, I think we should go ahead. I'll make the motion.
Second.
I'm sorry, who seconded?
Commissioner Mann.
Oh, thank you very much. I have the list here, so I'll just go through it. Amin Al-Sarraf.
Yes.
Corey Friedman is not here. Zahir Aman.
Yes.
James Meeker.
Abstain. I wasn't there.
Abstain. And Kim Savage.
Abstain. I wasn't at the meeting.
We have 2 votes. I'm not sure that.
So the motion does not carry, although it's my understanding per Robert's rules that even if you were not present at the meeting, you can still vote to approve the minutes. So if our 2 commissioners who abstained wish to do that, I think we would like to give them the opportunity to.
Well, given the affirmation of the legitimacy of the minutes by Selena, who's my appointee, or who appointed me, I guess, I will change my vote to approve.
I appointed you on the other commission. This one, I think the bar appointed you.
Oh, yeah, that's right. Anyways, I changed it. I approve.
It appears accurate to me, and I know I'm not a voting member, but I did read through it. It looks accurate.
Thank you. I think that does give us 3 yes votes. The motion passes.
Yeah, the motion passes. And Dawn, are you back? And Dawn, are you back?
It doesn't sound very much back. The next item on the agenda gets us all the way up to the discussion and action items, which may take some of the pressure off. I'm not sure who was going to be giving these conversations, but
I believe Erica can run the PowerPoint.
Great. The first is to discuss and approve the recommendations to the Board of Trustees on the definition of indigency and methods to demonstrate services to indigent clients. So, Erica, are you a panelist or a co-host on this? There we go.
Can everybody see the PowerPoint?
Yes.
Perfect. So thank you, Dan. Yes, we're going to be talking about the definition and ways to demonstrate indigency. And the members of this working group are Banashe Aklagi, Jim Meeker, and Chris Schreiber from the Commission. So some of the issues that were identified initially related to this topic are ways to clarify the definition of indigent person under Business and Professions Code section 6213D. That statute has basically 4 main elements. One is the definition of indigent person based on income at 125% or less of the federal poverty level. Recipients of supplemental security income or eligible for services under the Older Americans Act or the Developmentally Disabled Assistance Act. Another way to qualify based on the pro bono allocation that some organizations receive, having a higher income threshold using HUD guidelines, and a section on deducting for disability-related medical or special expenses when determining income. And then the second topic, which we'll talk about, is ways to demonstrate indigency in reporting on the impact litigation and advocacy work of organizations. Questions have frequently come up related to how to demonstrate benefit when working on behalf of a group or a class of persons rather than providing services to individual clients. Our governing authorities that control here are the Business and Professions Code, which is commonly referred to as the IOLTA statute, the state bar rules, and then we have eligibility guidelines for legal services projects, support centers, and standards for financial management systems and audits. We're mainly going to be focusing on the IOLTA statute and the eligibility guidelines for legal services projects. So the two statutes that are relevant here, as I mentioned, are 6213D for the definition of indigent person. And it's relevant because under 6218, there is a requirement for grant recipients to establish eligibility guidelines. The statute 6213D has some ambiguity. It does not have definitions for things like income. And so it can create some inconsistency when organizations or grant recipients are implementing their eligibility guidelines. And the purpose of this analysis and discussion is to eliminate some of that ambiguity. And then as it relates to demonstrating indigency through the ILAW process, we'll look at guideline 2.3.4 of the eligibility guidelines for legal services projects. Currently, there is no state bar rule that addresses these topics, and the hope or the purpose potentially of this discussion is to develop a state bar rule that will clarify some of these issues to ensure consistency and clarity for programs. So this is the actual text of 6213D. As I mentioned, it has sort of those 4 sections that are highlighted in different colors. And I will refer back to this throughout the discussion. So as I mentioned, under the statute, things like income and household are not defined. When the working group first discussed this, the preliminary recommendation was to adopt the Legal Services Corporation definition of income. It was not necessarily to adopt any other regulations required by the Legal Services Corporation, but rather the definition of income that they have in their regulations, which provides various categories, whether it's from wages and salaries, things like veterans benefits, pension plans. It provides a category or a list of categories of income that are fairly easily understood. The reason this was necessary, as I said, is there is no definition in the Business and Professions Code for this, as well as the reference to the federal poverty level. When you look at those guidelines, they explicitly say they don't tell programs, for example, whether to calculate income before or after taxes. So that's why we looked for other sources of guidance, and the Legal Services Corporation provided sort of more definition in that respect. After circulating that recommendation to the legal aid community, there was an endorsement of raising the threshold, the income threshold, from 125% to 200% of the federal poverty level, or to consider the area median income. And I just want to note that these are 2 different issues. One has to do with the actual definition of income, and one has to do with the level of income or the percentage of income threshold. And I know LAC provided some detail related to that, but Selena, I don't know if you wanted to comment on that aspect related to the 200% federal poverty level or the area median income.
I'm happy to do it now or later if you're in a flow. It's up to you.
Yeah, now would be fine. I think I don't want to misstate anything that was the feedback from the community.
Yeah, sure. So we at the Legal Aid Association of California convened legal aid programs over 2 phone calls. We also talked to a lot of people by phone and by email. And I think that the comment that Lynn made earlier is pretty is common in our community, is that 125% of poverty is too low. And I think that the community, I will say carefully, I think the community is united in moving it above 125, or in recommending to move above 125. But LAC needs to do a little bit more work to figure out where is the consensus. I think that most believe a minimum of 200% would help with a lot of these issues of folks who consider themselves to be very, very low income, but they still are at 150. And also the mismatch between organizations where, with a lot of other funding, including funding that is Shriver funding or other, they can serve above 125. So they're still doing the work. And especially now with the changing income of households, where it's really a snapshot in time where they're at because of COVID-related income loss. Folks feel that moving up to 200% might be appropriate now. And then where there's not agreement yet, and we want to figure out by doing a little more surveying and more conversations, is whether we should tie to AMI. I think that, as Lynn mentioned, that moves the income threshold much higher. It is more responsive to the geographic differences in California. And oh, I see your question, Kim. It's more responsive to the geographic differences within California. But I think that there is a little bit of concern in our community, and that we need to figure that out about how high we raise it, which then opens up the IOLTA community to a lot of organizations that we don't really think of by common sense as legal aid. Because if they're doing a lot of sliding scale, they're serving more over income folks generally, but they still, they're 55% of their work is free, but it's to higher income folks. So I think we should need to do a little bit more research to figure out what it would mean if we moved it above 200%. And I think that is pretty much the general thinking is yes, 125 is too low and move it up. Oh, AMI, area median income. And Judge Seligman, area median income is very specific to the area. You can go on the website, and if you're using like HUD classifications, there's extremely low, which I believe is 30% of AMI. There's very low, which is 50% of AMI. And thank you, Erica, for telling me I'm not wrong. And then there's low income, which is 80% of AMI. And so if you're talking about HUD standards, that's frequently the 80%, which is close to what pro bono allocation programs can use at 75, but it's not the same. I mean, 80% is actually significantly higher than 125% of poverty. And
Erica has a chart later. Sorry to interrupt, Selena. Erica does have a chart in her presentation so that we can you can visualize what the break. We took a couple counties, Erica did, and you can visualize what the 125 versus 200 versus AMI.
Thank you. And then I may have to defer to Jim on this. Shriver is 200%, is that right? For most services, except for the stuff that's just Shriver includes a number of different services. There's self-help services, there's kind of expanded self-help services with court innovation, and the full scope representation. Jim, I believe it's 200%.
I think so. Bonnie would be the best to answer that, but I think because under the LSC standards, it generally, with all the exceptions, you end up being at roughly the 200% level. So it's used as a default.
Thank you.
And just to add to what Selena was saying, so the State Bar and LAC, we've been in conversations. Should this committee choose to make a recommendation to the commission in terms of pursuing a statutory change, we do have a kind of a action plan that we'd like to present to you later on in this presentation of how we can move things forward.
Yeah, and just one final comment which I think that is reflected in Erica's memo, is that the time does feel ripe. I think a lot of programs are very nervous about expanding eligible income, the client eligible pool at a time when IOLTA is shrinking. But I think right now, with everything that's going on with the COVID crisis, with people who are newly living in poverty, with people who may be popping in and out if they are able to get some temporary funds and then they're furloughed again, and with unemployment insurance, it makes sense to make the pool of eligible clients slightly larger so organizations can make their own prioritizations based on their substantive legal area and their own capacity at the time. And then we, of course, at LAC are working on expanding all other sources of funding, since we know that IOLTA will shrink next year.
And Jim, did you still have a few questions that you want to raise now before the general discussion?
Yeah, I do. On the first question really takes off of what Selena was talking about. I remember when I was working or serving with the working group that there was an issue of opening up to 200%, and the general consensus was the politics and the changing political landscape was such that too many people were worried that if we opened it up, that other worthy foundations and organizations would go after these funds, such as victims of crime. And so I don't know if the political landscape has changed. I remember talking to Rich a lot about this. Perhaps he has more updated information, but there was a lot of concern then that if you open it up to changing the statute, other people are going to go after the money. Mm-hmm. The other issue is on the AMI, the possible impacts on other things, such as the funding allocation formula. If you use a AMI, then there's going to be a radical shift of funds to urban areas, because as presented earlier already, that the AMI more accurately reflects the funding inequalities in urban areas, but urban areas have a lot more people. Given a fixed pie, a larger slice is going to go to urban areas if we use the AMI standards, not for eligibility of clients, but for the allocation of funds. And of course, to me, that's going to be the next question. If we change the funding standards for clients, why don't we change the funding standards for the allocation formula? And then finally, the last question is on AMI, is in terms of, is it based on household? Is it based on income or individuals? I don't know. And the other question is, what is the area that is used? That is it the county area? Is it the census tract area? What do you do with programs that go across counties? Do you use the average between counties, or do you weight it by population size? What do you do with programs that go sub-county areas, such as the what used to be Legal Aid of Southern California that has Norwalk and Compton and Southeast LA? How do you do that? Is that tracked or is that by county? So those are the three kind of technical questions I had for people to consider.
No, and those are really good, really good questions, Jim, that we've already started to talk about within our office in terms of if we do bring up the threshold, how will it play out in the formula allocation? Because right now, by statute, we run it based on 125%, and that's how we get the percentage, the allocation within each county that the county is entitled to. And then we divide up that county allocation amongst the program. So if we're raising it, then are we proposing to also change the statutory formula? We can't answer all your questions, Jim. We're actually, and this will be part of the action plan proposal to this committee. We definitely need to do more research. And we don't know whether, how we run the formula right now is through our online grant making system, Smart and Simple, that was built out to run it based on 125. We need to see with our vendor whether we can do a test run, say at a 200%, and maybe possibly share that with the community to see, we can't go back to 2019 expenditures and run it based on if they have 200% qualified expenditures. What we can do is take the 125% expenditures, but run the formula based on 200% and see how that would shift award allocations. Another technical response to your last question is in terms of counties. Right now, according to the formula, programs apply per county. So it's not they don't apply across counties. They don't apply statewide. Support centers get a statewide allocation, but QSPs are per county. So I don't know if that would, but all of these kind of nuances are things that we need to dive a little bit deeper into if we're going to propose a statutory change. But the really excellent points.
And Dwana had just one comment on the political piece. Jim, I think that Dwan wants to tee this up later for a broader discussion about how we could do it via legislation. So I don't want to dip too much into that. But specifically on the issue of victims of crime, we've been able in California to open up significant funding through the Federal Victims of Crime Act. And so there is, Lauren would know this better than me, but there is somewhat around like 7 to 10 million a year for victims of crime, and Lauren, feel free to correct, that is fairly new funding in California over the past several years. So at least for the one special interest group of making sure we represent the victims of crime and their, folks who are getting evicted because they've been a victim of a domestic violence situation, we do have funding for that now.
And yeah, and once we talk about kind of the action plan towards the end of this Erica's presentation, the state bar, we've been in a lot of conversations with Selena as well as state bar management to see if this is actually a right time to pursue it. And it seems like there's a green light on all fronts right now, that it is a kind of a time. There is still some worry in terms of when we open up the statute, are we going to be opening up the entire statute? And, Selena has a really good kind of suggestion for that. But why don't we save that conversation, that piece until we get to that point, and then we could share it with you. Erica, do you want to go on?
Thank you. So the one of the last things that was brought up in response to the working group's recommendations, the preliminary recommendation was to explore exceptions to income, defining situations where an exception to gross income might be appropriate. One of the suggestions that we received from the legal aid community was to consider the exceptions under the Legal Services Corporation, which I think Jim alluded to, which is that it essentially allows going up to 200% of the federal poverty level, and then with the income exceptions qualifying under the lower threshold of 125%. There was also a question about confirming appropriate approach to income for minors. Many programs who have minor clients basically count their income as zero, and wanted to confirm that that's appropriate, or if you should be looking more widely at their household or other individuals who might be responsible. And the memo, I think, outlined some situations where it does seem like that's appropriate, and we're open to receiving more feedback from the community about whether it's related to minors or otherwise, where exceptions might be appropriate. I think that's still an open question about how to define those exceptions and how specific to get. So, and then the other income-based category for the definition of indigent person relates to programs that receive a pro bono allocation. There is a higher threshold, which is the section of the statute that's highlighted in green here. It says, with regard to a project that provides free services to attorneys in private practice without compensation, indigent person also means a person whose income is 75% or less of the maximum levels of income for lower income households as defined in the Health and Safety Code. Essentially the effect of that is that pro bono programs are allowed to use a higher threshold for their clients. And so that's one category. We proposed in the preliminary recommendations to use the same definition of income for when screening for eligibility as you would for the 125% of the federal poverty level. I know this is another area where I believe, Selena, you said that you wanted to make a comment on behalf of the Federal Family Violence Appellate Project.
Yes, and please, it's attached to, thank you for making an attachment because I want to make sure I get it correct. So this is mostly around, and I think this will mostly be fixed if we change to 200% of federal poverty. And I think that part of the issue for support centers, which Juan can I think clarify, is when a support center gets a referral from a QLSP, there may be some lack of clarity around what happens if the referral is a client who is at 175% of poverty versus 120% of poverty. Like, how does the support center count that? And I understand that the support center should be able to count it if it's a referral at any income level. Is that correct?
Yeah, so there is a little bit of confusion. And it's, Erica, can you actually go to the slide of the statute, because that might help the committee kind of visualize what we're talking about.
And there's two issues for family violence
it's
project. One of the issues for family violence project is a support center specific issue that, what do support centers do when they're referred a client, or they co-counsel, or they do the work for the clients. That's one issue. The other issue is the definition of project, which is to me like a statutory interpretation issue. So there's two kind of issues together.
Yeah, so generally speaking, if a QLSP is going to refer a case to a support center and that client has been screened and is eligible for the QLSP services under either 125% or the pro bono allocation, that as it currently stands is acceptable. So if the client is eligible for the QLSP services, they would be eligible for the support center. As far as the statutory interpretation, I think Brady looked into this a little bit. Brady, I don't know if you're on the line.
Yes, yeah. So, I mean, a project in the context of the statute, we've always interpreted, and I think that the best way to interpret it is referring to the actual entity, the actual grantee. If you look at 6213A, where it defines what a QLSP is, it's saying nonprofit project incorporated in California. So it's the project is the entity, not some specific little program that they're running. In other places in the statute, project is the entity. So that's how we've interpreted it.
And I think that Aaron and a few others interpret it the more inclusive way, which could mean a sub-project within a QLSP, could be a pro bono project. So if an organization serves a client at 175% of poverty by or whatever, 60% AMI, something below the AMI threshold, and by referring that to pro bono attorney within their network, then there's an argument that even though it wouldn't count towards a pro bono allocation because there wouldn't be a significant level through the pro bono test, that they should be able to count that client as a qualifying expenditure. So
my understanding is that that's not how we've ever interpreted it, and that's not consistent with how the word project is used within this section. In fact, if you look at 6213A, so we would disagree with that interpretation.
Hi, this is Dawn. I'm sorry, my internet cut out, so I had to call on my phone. Can you hear me?
Yes.
Yeah.
I'm sorry. So I think I caught the last piece of Brady, but did we talk about in terms of the income screening for that was required for support centers?
Yeah, Duan. So I just sort of weighed in on the question of what a project means, and you and I discussed that.
Yeah.
Basically repeated our discussion. What I'm still not understanding so much is why this is an issue for support centers, given how support centers are defined.
Oh yeah, so this is I did have a lengthy discussion with Aaron from Family Violence Appellate Project, and these were the public comments that were just posted yesterday, and I had forwarded over the weekend to the committee members. So I think a lot of it has to do, and I don't want to misrepresent Aaron, but this is my understanding, and Selena, you can clarify, is that Aaron and some of the social support centers were under the impression that they had to income screen for clients that they provide direct services to. So as you all know, because the primary purpose of a support center is different than what it is for a QSP, the field programs provide the direct services. So support centers are not prohibited from providing direct services, but the guidelines lay out exceptions for when, if they do provide direct services, they can count as qualified expenditures. So those exceptions are if it's at the referral of a QSP, being co-counseled by a QSP, or at the referral of a pro bono attorney. So there's been a lot of confusion around this in the office and amongst support centers in terms of income screening, because there is no authority to say that a support center has to income screen or doesn't have to income screen. So I think this office has flip-flopped over the years. However, the last few years when we went back, and I would say this is at least since my time, so at least 3, 4, 5 years now, when we went back and did a sweep of the statute, because there were no guidance in terms of income screening, we have told support centers, you do not have to income screen. As long as that client comes through at the referral of a QSP, being co-counseled with a QSP, or at the referral of a pro bono attorney, you do not income screen. And this is something that we need to revisit during codification. You know, Aaron's concern is if this gets, well, first off, she wasn't clear that she didn't have to income screen, so I clarified that again for her. But she is also worried that if the committee and the commission decides to change the status quo and put a state bar rule in saying that support centers have to now income screen, then she would like to advocate that for this broader definition of project. And so that's the tie of why you know, Aaron thinks that the Family Violence Appellate Project thinks that this would impact them. I don't know if this feeling is pervasive across a lot of support centers. Aaron's program is support center is unique in that most of their support activities has to do with you know, they provide they do work on appeals. So the majority of their work is direct services in nature. Their support services is just direct services in nature. And that's unique amongst all of our other support centers. So I don't know if it's implicated in the same way. Practically speaking though, because support centers share an equal amount of their award allocation doesn't change based on their qualified expenditures. It's practically, it doesn't really have a practical implication. And that's the piece that Brady and I have been struggling with the public comments, is that it doesn't, I wouldn't say it doesn't impact them, but because it doesn't go towards their award allocation, our reading of this piece of the statute, we feel like it really, it impacts QSPs. So, but so that's one issue. But then, and I think I mentioned this in the email to the committee, the piece that, I thought that deserved a little bit more, a closer read by this committee and the commission is that, the state bar's long-standing kind of interpretation of this piece of the statute is to tie a program's ability to use a higher HUD income threshold with them receiving a pro bono allocation. That is not kind of explicit in this statute. That is a statutory interpretation, and that's where I think, and maybe Brady has already said this. That's where we're asking OGC to answer the two questions: whether our interpretation is too restrictive, and we didn't have the authority to make that type of interpretation, and then secondly, even if it's not, putting that aside, can we go with a more liberal interpretation of the term project?
So I discussed what a project is in the context of a statute, not necessarily tying this sentence here into the pro bono allocation requirement. And I can explain that. The issue here is if you read just that sentence and that's up on the screen in green, with regard to a project that provides free services of attorneys in private practice without compensation, indigent person also means that a person whose income is 75% or less of the maximum, so using the AMI, accepting the state bar's interpretation of project as an entire entity, one could read that sentence as saying any project, any recipient that provides any free services at all could use that higher income standard. Historically, as far as I'm aware of, the state bar has never interpreted it that way. Our guidelines do not. And I think that our interpretation is justified by the statute, because if one were to read that, if a program could use the higher threshold simply by having one pro bono attorney provide 1 hour of free service, it would completely swallow the default rule, which is 125%. So while the statute doesn't require our interpretation, we certainly can make that interpretation as a matter of regulation.
And to clarify, I don't think that that's what programs were arguing for. I think the
No.
program was saying if they, if one of their project areas was really a pro bono project within a larger organization, what about those clients within that project?
Right. No, I think this was an example of Dwan and I just noticing that there was another potential issue there that we wanted to at least acknowledge.
So, and I think Selena already made this point. It's the issue might be a little bit moot if we're moving up to a higher income threshold. I did raise that to Erin, but she said unless we move it up to the 75% of the AMI, her public comments would still stand for us to do the more generous reading of projects. So I did want to communicate that because that's what Erin had expressed to Selena and I. So I don't know if there are kind of thoughts from the committee members on these issues. Okay. So Erica, do you want to just move?
Duan, this is it, if it's okay?
Of course, of course.
I just have one thought. I think it's really helpful to be able to go through and walk through this. And I think that as I was reading all of this material, I was trying to understand, which is one of the things that one of the speakers earlier kind of spoke about, the difference between the urban versus rural communities, and what does it mean to be eligible for services, which seems like then it also kind of gets into a question of what does it mean for urban versus rural communities to be eligible for funding for services. And so as we kind of move through this, it's just one of the things that's top of mind for me, because I think for a lot of rural communities, they don't really have access to the same funding sources that exist in urban communities as well. And people in those communities are suffering also. And so trying to figure out a balance that works for the entire state. And then, you know, I think that there was this other piece, and I don't know if we'll get to this a little bit later, but I believe it was in some of the comments, the written comments that Selena submitted, but being able to see kind of like a chart of what the distinction is, because some of this just has an overall policy feel, but once you start to actually see the numbers of what people live on versus what the cost of living is in their community, it just helps to provide, at least for me, like a little bit of a better tangible understanding of what kind of standard of living someone is living under, and then how that opens them up for certain legal services. So those would be my two comments, but thank you for all of this.
No, and we do have a chart coming to help you visualize. So maybe if Erica, do you want to just move on?
Yeah.
There you go.
So this was based on LAC's suggestion to kind of have a chart to visualize these different income levels. On the far left is the current 125% of the federal poverty level, which is not responsive to variations in income or urban versus rural. And so for a family of 4 at 125%, it's an annual income of $32,750. If the committee and the commission were to propose a change of moving up to 200%, that would bring it up to $52,400 for a family of 4. And then to the right of that, and I'm sorry, I probably should have chosen one example of a more rural county to give that contrast, but I did include Alameda County, Los Angeles County, and then the state of California. So in the third column, you have the HUD very low income category, which, as Selena mentioned, is about 50% of the area median income. And so for Alameda, that's $65,250, but in LA, it's $56,300. And if you look at the statewide average for 50% of the area median income, it's down to $43,550. What corresponds to the HUD low income categories, it's about 80% of the area median income. And so you can see a family of 4 would be considered low income in Alameda County under the HUD guidelines if they make $104,000 or less. I put at the bottom the actual area median income for each of those counties or for the state. You can see from those numbers that it doesn't exactly track that. For example, the Los Angeles low income category is 90,000, but the area median income for the whole county is 77,000. So my understanding, and if Jim or Selena is more familiar with the calculation, is that these categories are typically 80% of the area median income, but based on different factors, there's an actual calculation based on, say, like the fair market rental of a 2-bedroom apartment in these areas. And so it may come out sometimes that the low income category, for example, with LA is higher than what the area median income is actually for the whole county. So it doesn't always track, is my point, but it is, generally speaking, the general categories is that very low income is 50% area median income and low income is 80%. But again, I'm sorry I didn't include a rural county, but I do think that the 3 that are included here can give you a sense of the variability depending on how you look at it, whether it's at the county level or statewide.
And Erica, we had some comments from some committee members wanted to comment.
There were some comments in the chat, Erica, from Kim Savage, James Meeker, and Richard Reines. Can you see them?
I cannot. Yeah.
Okay. Kim Savage asked Selena, what is this number? What number is Shriver using? Jim Meeker asked a couple.
That was already answered, Kim. We talked about that, and we answered that previously.
Jim did have another question. I think whether it would be possible to add some pop to the chart And I think if this would be, used again in another location, there's all kinds of ways we could shape the data, but numbers are
it'd be
pretty
nice.
intense.
It'd be nice to have population, and also it'd be nice to add a county like Imperial to it.
Population.
Yeah, we could certainly do that for the next iteration of this.
Yeah, and one thing I did want to mention in terms of the consideration between using the federal poverty level or area median income is that under the current statute, and this was mentioned earlier, is that the formula for determining grant allocations by county uses a pro rata share of 125% of the federal poverty level by county. So it's not, we haven't quite figured it out yet, but it would take some revisions and it would require a change, I think, to the statute, particularly if changing to the area median income. It's not clear exactly how that would be calculated in a way that's equitable. So that's something we would need to research a little bit further.
Yeah. So we don't think it's impossible, but it would make the calculation a lot more complicated. And that's a piece that our office needs to really sit down and think through the how the formula would play out if we moved it to AMI.
And I really appreciate Jim's point about looking to see how that would impact funding for rural counties, because I suspect that would mean a complete reallocation if we look at AMI, and the rural counties would lose out on so much funding.
Yes.
And to Zahira's point earlier, there's so much fewer funding available for rural counties because of lack of access to foundations and to pro bono attorneys and to, all of the funds that private attorneys give. So I would be very concerned if we move to AMI, especially for distribution.
Yeah.
There's one other question, if I could raise a technical question, is that all of this stuff is relying on the American Community Survey done by the census.
Yeah.
And the issue is a census that American Community Survey is not done every 10 years like the decennial, but is done at different time periods for different levels of population. Now, I'm speaking off the top of my head now, which when an academic says that means I'm guessing, or it's very speculative, needs to be checked. But best of my recollection off the top of my head is that for urban areas, the data is updated yearly. For suburban areas, it's either 2 to 3 years. And for rural areas, it's 5 years, which means something like the COVID impact and the recession that COVID has created, that's going to show up for the rural or for the urban data immediately for 1 year. But it may not show up for places like Imperial County for another 4 years. So there has to be some understanding. Are you going to do, which data are you going to do it on? The 5-year average or the most recent data?
Well, we currently use the 5-year average, Jim. And this is something we also is a codification topic that we'd like to revisit to make sure that we're doing it correctly. So we do the 5-year beta based on, and this predated a lot of us in this office. We had, I believe my understanding is that at some point we had reached out to some researchers and they said that's what because of these various kind of, surveys, that the 5-year was the most appropriate for us. But that's what we currently run it on, is the 5 years.
Good to know.
Were there any other questions either on this chart or on the different?
Oh, Judge Seligman has a comment, Erica.
I'm sorry, I can't open the chat right now.
The question was whether we are required to tie the eligibility formula and the distribution formula together. Do we have to use the same standards? Did I get that right?
Yeah, so right now, they're in 2 separate pieces of the statute. So right now, we have the Indigency 125, and then there's a separate section of the statute that says how we're supposed to run the formula, and that's based on 125. If we were going to pursue a statutory change, I believe those 2 pieces should be revisited together, because it's a little bit, to me, not aligned if we change to 200 or AMI, but we leave it at 125, how we run the allocation.
The reason I raised the question is I think Celine and others have raised a very serious issue. Obviously, we don't want to crater the funding for rural areas. On the other hand, we want the eligibility formula to reflect reality. And the reality is the cost of living is much different in these two different areas. So I'm just wondering if we can unlink those two concepts and come up with an eligibility formula that perhaps does reflect the AMI for an area. So it's more realistic about what's actually happening. But the distribution formula would not be tied to that. I don't know if there's any reason why we couldn't unlink them.
Yeah, I don't see why not. And that's something we should explore as like possibilities and why we should or shouldn't do.
So the other areas of the statute that were mentioned in the memo related to the definition of indigent person were related to eligibility for supplemental security income, eligible for free services under the Older Americans Act, and eligible for services under the Developmentally Disabled Assistance Act. And under one interpretation of the statute, which is not how we've ever interpreted it, but it might be read to say that persons who are eligible under these three categories would need means testing. We haven't interpreted it that way and wanted to clarify that. And so the proposal was for individuals who are receiving SSI, for adults who are 60 or older, and for persons who would be eligible for services under Title 42 of the United States Code would be considered indigent persons within the meaning of the statute. None of these topics received any significant feedback or requests for any changes, so that proposal still stands.
I think there was a question from Kim Savage.
I brought this up earlier, I think in a full commission meeting regarding what I view as problematic, and it's the third prong of developmentally disabled. It's extremely limiting. There are people who have a disability, but it is not a developmental disability. And I think this is problematic because not everyone who has a disability might be captured as a recipient of SSI. So I would propose that in some way we address that, maybe with a comment or a clarification, because I think that if someone meets the definition of disability, and of course we have to decide under what definition we're using. I prefer the more liberal one under the California Fair Employment and Housing Act, but someone else might say we should be using the Social Security Administration's. Anyway, I just think it is limiting, it's problematic, and hope that we can do something about that. And I'm really quite surprised that nobody from the legal services community brought that up.
The language, Kim, the Developmental Disabled Assistance Act, that's statutory.
I get that. I mean, I get that, but I think that maybe we have the ability through the rules process to provide a broader interpretation. I don't know. I've got a problem with it.
and you know, Selena has had conversations with Catherine Blakemore. Selena, I don't want to put you on the spot, but would it be okay to share that?
Yeah, I mean, one of the things that we were discussing is whether or not we could tie the definition to Medi-Cal eligibility, which is more expansive than the developmentally Disabled Assistance Act. And so that was something that there was not clear consensus from the community, but the issue was raised. So I think it's worth a conversation and perhaps a little bit of additional research. Medi-Cal has a lot of eligibility factors, but looking at the disability factor within that might be appropriate.
Well, that's perfect. Catherine being the one to help dive into this.
You know, and I think, you know, I'm not completely familiar with, but I do. Isn't it 138, Selena? The Medi-Cal threshold. So if we're going up to 200 or AMI, it might be moot point?
Someone else probably is more of an expert on Medi-Cal eligibility on this call, but there's oh no, I don't see anybody who would know more than me. But I believe that there may be a different qualification if you're eligible based on your disability status.
Gotcha.
There's a number of different thresholds, and Medi-Cal is really interesting because there's also, you can be eligible for Medi-Cal if you've been diagnosed with breast cancer. So there's a list of things depending on what bucket of Medi-Cal you get in.
Yeah.
You can tell I have not done benefits work.
Okay, well, I'm glad we're going to take a deeper dive into this. Thank you.
I think we should.
And so just to summarize the working group's recommendations about clarifying the definition of indigent person, after receiving the feedback from the legal aid community, the consensus was to pursue some sort of statutory change to increase income eligibility. You know, based on both the written feedback and today's discussion, the suggestion is to survey the legal aid community regarding that threshold amount and to do a little bit more research based on the points that were raised today about sort of the impact that would have. One thing to note is that if the statutory change is pursued, that it may cause us to pause on making other changes related to this topic just in the interim to ensure that there's consistency once those changes are finalized. But the recommendation was to adopt the definition of income under the Legal Services Corporation regulations, whether it's under the definition of 125% of the federal poverty level or the higher threshold for the pro bono allocation, to adopt some sort of clarification to the categories that are based on other qualifying characteristics, to confirm and reiterate that there should be a deduction of disability related costs before calculating income. And then, as I mentioned before, looking into the exceptions, clarifying that and sort of defining what would be appropriate exceptions to income if a new state bar rule is enacted. So I don't know if there's any more discussion on that topic. The next one would be talking about demonstrating an indigency under the Impact Litigation and Advocacy Work Report.
Erica, should we talk about timeline now? I know you have that slide about timeline, or do you want to save it until the other piece?
Yeah, we can talk about the timeline.
Thank you. I think the timeline would be helpful because so much of this, once you start opening it up, it's like, you know, you see layers upon layers of additional research needed.
Yeah. So in terms of the timeline, you know, a lot of these issues, we're not going to be able to kind of finalize recommendations and package it to bring to the commission because they're so related to each other. But the piece that we need from this committee is whether there's consensus around moving forward with investigating more to see if we should pursue a statutory change. So if we did that, then you know, our office would work in partnership with LAC to develop a survey and send it out to see whether there is actual consensus from the community to pursue, and if so, at what level. But we need to do research on our end to present the you know, the facts and the options to the community. And like we just discussed in just the last hour, it's uncovering kind of a lot of issues that we have to kind of get a handle on before we can even develop the survey and send it out. So that would be one first step, is to send out the survey, get that back, do a little bit more research, perhaps run some test allocation based on the options. Then we would bring it to, you know, Erica and I went back, do we roll back to the committee and then bring it to the commission? But our suggestion is then to bring it back to the full commission and have a full commission discussion, since this is such you know, a big topic and it has such wide implication that it probably warrants a really deep dive, full discussion at the commission. So it wouldn't roll back to the committee. It would go, all that information and that data and the results of the survey would go back to the commission to approve. And if the commission approves pursuing a statutory change, we then need to bring it to the Board of Trustees. The Board of Trustees, there's a November meeting and then there's a January meeting. And looking at the calendar, the November meeting is just way too quick for us to get the information we need. So we propose bringing it to the Board of Trustees in January. They need to kind of approve our legislative priorities for the state bar. So once we have their approval, then the state bar can more formally reach out to legislative staffers and work in conjunction with Selena Lack to pursue the statutory change. And Selena and I spoke earlier this week, and we think this timeline is doable because what Selena's proposed now, I could let Selena kind of elaborate that. There is a little bit of anxiety in that in pursuing a statutory change, it's going to open up the whole entire statute and perhaps change it in ways that we didn't anticipate. But Selena has a suggestion of tucking it into budget trailer language, and then that might limit the changes. Selena, do you want to elaborate on that piece?
Not into budget trailer. I think we can do it as an amendment to the state bar dues bill.
Yeah, sorry.
Yeah, so just mechanically, it's a little bit different. Yeah, so I think this is a good year politically to do so because of the expanded number of people who are living close to poverty. And we have, as Jim said in the past, we've been really worried about the politics of opening up the statute. Even if we want to make a minor change, does that mean that some legislators will say, oh, this project over here isn't funded? Can we scoop out some of IOLTA funding for this purpose? And some of equal access funds for this purpose, since equal access fund flows through the IOLTA formula for the most part. And I know I've talked to Toby Rothschild, and I believe some that were presented in the past as possible changes were things like funding public defenders. And I've even heard ideas, at the Board of Trustees meeting recently, where one of Mark Broughton suggested perhaps we use IOLTA funds to help defend attorneys who've been accused of stealing from their clients. So there's a lot of purposes for which we do need funding for legal services, but I think that a lot of them are not appropriate uses of the IOLTA funds. And so that's why we have been worried in the past about very worthy causes scooping out something that's meant, to really fund civil legal services to indigent Californians. But I think that if we do it as part of the state bar dues bill, it's an amendment. It's something that can be fairly uncontroversial. It's a very minor change if we just change the 125 to 200%. And it's something that I think that both the Senate Judiciary Committee and the Assembly Judiciary Committee would support.
Yeah, and we ran the idea through executive staff at the state bar, and we're in agreement with Selena and Lack that if the community, the one piece of feedback I got is this needs to be unanimous wasn't what I was told, but there needs to be consensus in the community that we want to do this. So that's why we want to get more data points, more formal data points, so that when we go and pursue the change, we could say to the legislature, we've surveyed our 100 programs, 90 something percent or 100% are in support, because they would be hesitant to do a change if there's a split in the community.
And I do suspect that if we did move to a higher AMI threshold, there would be a split in the community as organizations started thinking about how it would impact their ability to serve their own clients, and potentially adding, I wouldn't even know, maybe 20 or 50 more IOLTA funded programs if we really expanded income eligibility. So I think that might cause a split. But I do think that 125 to 200% feels like a very conservative change in light of the fact that many of the organizations are already serving those clients with other funds, and they're just scooping it out of their QEs.
Yeah. So that, I think the staff recommendation, and again, we need to do a lot more research and run the numbers to see if we're going to stick with this, but we were leaning 200% because the AMI, though it would provide a lot more flexibility to programs, it's going to open up the floodgates for IOLTA funding in a way that I've been getting the question, well, how many programs then are you saying will be funded? That's an impossible question for us to answer. We don't know, but we do know that more programs will qualify. For better or worse. So, that's a philosophical question, whether, the commission and the community believes that's the best use of this funding is to provide opportunity for more people to have funding. The other way to think of it is because IOLTA is so low right now that it would be diluting the pot. So that's a policy question. But we can have a guess, but it's not going to be accurate. There are a lot more legal aid organizations in California than the 100 that we fund. So I guess any comments or questions on the timeline? Okay, Erica, we'll hand it back to you to finish your presentation.
So the other piece that the working group was looking at was how to demonstrate indigency in our impact litigation and advocacy work reports. So when work is performed on behalf of a group or a class of persons, whether it's an impact litigation case or some sort of advocacy activity, there are different ways to demonstrate that the work is on behalf of indigent persons. Both QLSPs and support centers need to complete these reports, but they have differing requirements. And so we're just going to be focusing on the QLSP requirements today. So the various factors under the eligibility guidelines that programs are to consider when they're making their reports about whether these are qualifying, meaning they can count them as their qualified expenditures, are to look at the forum, whether the named plaintiff is indigent, the definition of the class if it's an impact litigation case, a description of the group of individuals who would benefit, whether a majority of those who would benefit are indigent, the relation of the issues raised in the matter to the legal needs of indigent persons, and finally, whether indigent persons are disproportionately affected by the legal issues raised. The guideline goes on to say that for any of the activities that are reported, organizations need to provide their explanation about how it primarily benefits indigent persons. And the part that is most difficult or that we get the most feedback on.
Erica, you froze up there for a second. Right at the good part. Dwan, do you know where she left off, or?
Yeah, I do. Hold on, let me just. Oh, I think she's back. Erica, you back?
Yes.
Oh, sorry, internet issues today.
Great. So I was just saying that the report requires programs to explain how these activities primarily benefit indigent persons. And the part that's most difficult or seems to be the biggest hurdle in the feedback we've received from programs is that there's a requirement that they quantify the percentage of persons who would benefit from the services that are being provided and explain the basis. And we've received several comments and requests to change this because programs just sometimes don't have that sort of data or have acquired that data through significant expense and felt that the justification could have been provided through other means. And so this is what was kind of the focal point of the discussion for how to demonstrate indigency and whether any changes should be made. So when preliminary considerations were circulated to the legal aid community, the working group considered a few things. One was to set a minimum threshold to require even completion of the report. So whether, if an organization, if 10% or less of its legal services are devoted to these impact and advocacy activities, or 100 hours or less are devoted to these activities, that they wouldn't have to complete the report. And that's actually a piece that's in the eligibility guidelines currently, but isn't utilized or enforced. The eligibility guideline actually says 10%. It doesn't have the hours requirement. It's 10% or less of the legal services. So that was one way of trying to ease the burden on programs, is that if there's sort of a minimal amount of time devoted to impact and advocacy activities, that programs wouldn't need to complete the report. And then the other considerations were allowing the use of internal data if independent data is unavailable, to demonstrate a nexus between the needs of their clients and the legal issue. So for example, a lot of times part of our own evaluation and reporting requirements are the case summary reports at the end of every year, where programs provide information on the types of cases they handled, as well as the number of clients that they assisted. And so allowing use of data that's already being collected by the program would be one way of them to demonstrate this nexus. Another consideration was looking at ways to demonstrate a disproportionate impact based on the nature of the activity and the outcomes that the program expects if the activity is successful as they relate to the needs of indigent persons. So the way this was presented was sort of an and/or situation. So the and was because the desire was to set that minimum threshold. And then these two other considerations, it was either to choose one or to allow one or the other as a way of meeting the requirements for the reporting. So the feedback from the legal aid community in response to those considerations or proposals was to change the minimum threshold to be the greater of the two options, whether it's 10% of legal services or 100 hours rather than saying the lesser. So a consideration that came up in relation to that is if you used the greater of those numbers, let's say a program exceeded 100 hours, but it was still less than 10% of their legal services for a very large organization that could amount to hundreds of thousands of dollars that are not, could potentially not be qualifying, not to say that they wouldn't be, but potentially up to hundreds of thousands of dollars being spent on potentially non-qualifying activities that are not being reviewed. And what was mentioned in the memo was that the median number of hours per activity was about 125 in 2019. And the average number, because some activities really had a high amount of work devoted to them, so the average number was 358. So in the most updated memo, there was a mention that perhaps these numbers need to be revisited about the 10% or the 100 hours. But it did raise the concern that if you went with the greater, that 10% of services for a large organization could be significant. And then as far as the other two considerations, the community did seem to support the use of internal data as a way to justify the activity. LAC pointed out that some organizations already seem to do this, but it may not be widely known that that's acceptable. So making that clear to all programs so that they're on the same footing. And public advocates also commented that perhaps the use of data from community-based organizations or other legal services projects in the areas where the work is being conducted should be permissible. And again, as long as there's a reasonable connection between that data and the work being performed, that seemed like a reasonable expansion. So that was incorporated into the proposal. And then there was also support in the community for using the measure of a disproportionate impact. But there was a request to consider specific categories as eligible, such as homelessness prevention or domestic violence. And that wasn't something that the working group has had a fuller discussion on yet, about whether there should just be categories that are automatically eligible as being considered a qualifying activity or not. So that would require some further, I think, discussion and investigation. But I don't know if Selena or I think somebody from Public Advocates was on the line, if anybody wanted to add to that.
I think that John may have left already.
Okay.
The only thing I want to add is just that Erica, you touched on this already. It's just kind of like putting organizations on even footing. Is I think a lot of organizations who have had conversations with state bar staff over the past several decades on this issue. They know they can use internal data if they need additional support, but it's a lot of back and forth with state bar staff about what data is appropriate. And I think that a lot of organizations didn't realize that they could do that. And so maybe some organizations were struggling to find external data or getting it at their own expense when they could have actually used some internal data. So I think that this makes things more fair for organizations. And I did hear from several programs that it takes so much time to do the ILAW report. And I'm sure it's even more time for the state bar staff to review that. So anything that makes it somewhat streamlined in an appropriate way where there's still adequate oversight, I think organizations would support, because they spend so much, senior attorney time reviewing the ILAW report, drafting the ILAW reports.
No, that's a fair point, Selena, and we do recognize that. And I think we shared with the committee in the previous meeting that we know that there are programs that have struggled doing the ILAW report and have gone out and actually spent money hiring analysts in order to put together our report, and that's not what we want programs to spend their money on, to do this reporting. And it is very, very time consuming in our office. So if there's a better way for us to design the report so we can get the information but not be burdensome for both programs and for on the flip side for staff to review, I think we would support that. And I believe John's back from Public Advocate.
John, are you muted?
He has his hand raised.
Right.
Vicky, can you unmute him? Or Kim, can you unmute John?
Okay, can you hear me, folks?
Yes, you're back.
Yes, yes.
Awesome, thank you. Yes, I would just add that Public Advocates is supportive of the 3 options in this sort of more expansive approach. We would hope that options 2 and 3 are an and or, so that you don't pick one and not do the other, because sometimes the internal data, or as we've suggested, data from our clients themselves of their community constituencies might be helpful, and other times it might be we don't even have that data, but we can demonstrate through sort of the focus of the work and the legal issues and the impact, the disproportionate impact on indigent populations through number 3, that's how we are serving the indigency. And our an example is the impound, the challenge that the Lawyers Committee, our colleagues, made to the impound laws in San Francisco. I'm not sure the data supported that indigent folks disproportionately lost their cars to impound, but they were the clients, and they have the disproportionate need because they use their cars for work and sometimes even to sleep in. And that was the whole reason for the case that the Lawyers Committee brought. So it should have qualified. I believe it did. The last point I would make is just that we would urge you to go ahead and adopt this modification, regardless of whether the income level is raised to 200% of federal poverty or some other mechanism. I think this is something you could move forward on a separate and quicker time frame. Thanks.
Thank you, John. And Zahira also has her hand raised. Zahira, do you want
to? Yes, thank you so much. Yeah, I just wanted to sort of comment a little bit and build, commenting on some of what Eric has shared, that part of this change in terms of that difference between greater and lesser, I have a lot of concerns with kind of leaning towards the bigger piece and having it be greater rather than lesser, because it seems as if, those really large entities, 10% of their work, I mean, that's a significant amount of work for them to be doing that doesn't have a relationship to necessarily that they're calculating for Indigent communities, and they have the resources to be able to do the calculations. And so I would be, in terms of this recommendation, would be the lesser feels like it's more moderate rather than the greater piece, which could open up a lot of other types of work. And then, in terms of the use of internal data and other data, I'm curious in terms of the justice gap study that was done, and if there were any recommendations in there that could help in sorting out some of the data that is or is not used in different situations. I don't know that it is, but I'm just curious about whether or not that study would be of help as we're reviewing this particular piece. Thank you.
I think some of the justice gap study data could definitely be used. the one thing I will say is that in terms of how, you know, legal aid was defined in that study, it wasn't defined for respondents. So however people kind of responded about receiving assistance from legal aid and the issues that were brought might differ, I guess, from some of the data you may see from QLSP's reporting directly, which is kind of the difference we saw. We didn't intake census with legal services projects, and that's in the study. And then there was the NORC survey. So there are going to be some differences, I guess, in the way that that data came in or was reported, but not to say that it can't be relevant or viable in this context. I think I would need to go back and look at the study to kind of see where that would be useful. I don't know if any of my colleagues have thoughts on it now, though.
Yeah, I think that same question was brought up by another commissioner. And when we went back and looked at the Justice Gap study, like Erica's saying that, you know, it could be useful. I don't know it's directly on point, some of the categories. But we could do another review and see.
Sure. Were there any other comments, or did anybody else raise their hand?
I don't see any in the queue. Vicky, Kim, do you see any comments or?
There's no new ones in the chat. I don't see any, and I don't see any raised hands.
Okay. I think we can move on then, Erica.
So just to wrap up, the recommendation currently is to conduct some more research regarding those alternatives that were proposed by the legal aid community, and to report back to this committee with a final recommendation. And before the committee votes on recommending a new state bar rule, that we would have another round of input from the legal aid community once the proposed language is ready.
Erica, Selena has a comment or a question.
Just a quick question, because I know that, you know, some organizations are already using internal data. What would be a good example of the type of data that they would use that would meet the state bar staff's threshold for, you know, appropriate data that they could use, whether it's, as John mentioned, surveys from the client community? What are some good examples, I guess?
Yeah,
oh, go ahead, Erica, sorry.
No, I was just going to say, I think, you know, for example, one suggestion in the memo was when completing the case summary report, if looking at the historical data from the most, say, the past 3 or 5 years, if there is an issue that is coming up repeatedly and is affecting a, you know, significant proportion of the clients that are being seen by the agency, I think that would be easy enough to quantify. And to demonstrate that there is a nexus between the motivation to pursue that type of work and the needs of the clients they are serving directly or the individual clients they're seeing. Yeah.
Yeah, I was just going to say the same thing. If the organization, you know, does a survey of their own, it doesn't even have to be that formal, but it takes a look and has some type of tracking that this is an issue that is disproportionate impacting their low income clients. I think that's something that we can take. Selena, does that answer your question?
Yes, it does. Thank you.
Well, that was it for me.
So I think, Erica, the only thing we need to then vote on for your group is pursuing the statutory change, right, for the income threshold?
I had one question.
Oh, yeah, sorry, Jim.
Yeah, I'd just like to reiterate again, I'd like to see Erica's chart updated with the population data and including Imperial County or some other poor county. It just happens to be the poorest. And the other thing I was wondering if it'd be possible for you to run the formula on the allocation by county using the 125 standard versus the 200 standard, how that would actually produce different results, if at all.
You mean based on 200 rather than 125?
Have them both, the 125 and the 200, so we can see the difference.
Well, so that's a piece that we don't know. We need to investigate a little bit more. And I think I mentioned earlier, the Smart Simple platform where we run the actual formula was built out specifically for 125. We don't know whether we can manually put it in at 200 and for it to run the formula. It might need to be a manual calculation for us, which would be really difficult because it takes in a lot of variables. But this is something that we need to loop back to both Smart Simple. And we used to run it off of I don't want to bore you with the details, an internal state bar platform called AS400. So we have to go back to that to see if we can run the formula and modify it based on 200. We just don't know if it's possible right now. But if it is, that is definitely something that we would want to share with the committee as well as the community. So they have a sense. And the thing is, that's not going to be exact because it's not going to be based on their qualified expenditures at that 200% hold, but it would certainly still give them an idea of how the formula would play out at a 200%.
Yeah, that's why I was asking the
yeah.
allocation for the county, not for the particular program.
Yes.
So you don't need the expenditure data.
Yes, we could try to do that. And Jim, I don't know if you have the bandwidth, but if you do, we'd love to be able to work with you on the survey and then building out that chart as you suggested so that we can present it to the larger commission and the community.
Sure, feel free to ask. I got time. I can help you.
Great. Thank you so much.
I think Zahira has another comment or question.
Thank you. And just building on what Jim was sharing and a thought I had earlier is one of the pieces in terms of that chart, if we're building it out, is having some representation from the middle of the state. So if that is Fresno County or Tulare County, like one of those areas that's sort of in the middle. And since it seems like we're kind of looking across the state of Imperial being towards the southern end, if there's a northern county that is above Alameda that we can pick as well, that way we would have like a spread that may help to give us a better sense of it around the state. So thank you.
That's a good suggestion. And, we can work with Jim and be over inclusive if that helps visualize.
Yeah, so I think given the timeline that Dwan went over before, I don't think there will be another rules committee meeting before we would want to have a discussion with the commission. So I think the goal today was to see if the committee would recommend or direct staff to continue researching this and bring a proposal to the commission meeting with the goal of increasing the income threshold, but the specific recommendation to be determined.
If there are no questions, do we have a motion to accept that recommendation from staff?
So the recommendation specifically is it what we have initially is shoot, it blocked off Control V. Discuss and approve recommendations to Board of Trustees on definition of indigency. And what's the rest of it here?
That's sorry, Dan, that's not the motion. The motion is just for staff to be able to survey the community, get some more data points to then present it back at a commission meeting to see whether the commission wants to pursue the statutory change. And then it would go to the Board of Trustees.
This is Jim. I so move.
Second.
Great. Okay. So I could do roll call vote. Amin. And Amin texted me. He said he stepped out, so I'm not sure if he's back yet. Let me see if he's back on. I don't see him. So can we? I don't think we're gonna. So Corey's not here. So let me go down the line, and I don't know if we're gonna be able to approve this yet until the committee comes back. Corey's not here. Zahira?
Yeah.
Jim?
Yes.
Kim Savage?
Yes.
Okay, so we have three of
Yay.
5. So the motion passes. Okay, great.
Can I ask just a clarification? Does this preclude us from pursuing the non-statutory issues?
What do you mean?
The recommendation is we're going to do more research and we're going to, at the General Commission, talk about a statutory change. But we also have a number of non-statutory ideas, definition of income, some of these other ideas. And I put a thing in the chat which I would strongly recommend we not defer those issues pending a statutory change. The statutory change could be anywhere from a year to 2 years before that actually goes into effect. And in the meantime, we could clarify the income guidelines and clarify some of these other issues.
So we have a couple of options, Judge Sullivan, because I believe the Rules Committee at the outfront of the process wanted to wait to present the package that I don't know if it was the entire package, but a substantial portion of the package to the commission, then to the Board of Trustees. But I think we are open to moving some things up if that's what the committee would like to do. I know John and the public from Public Advocates, one of the suggestion was to move up the ILAW piece.
Right. Well, my only point is I don't think we should freeze our other activity waiting for a legislative change, because that could take a while. That's my only point.
Yeah. And we were, our thought was to roll back with this once we get a little bit more clarity. We wanted to do a little bit more investigation about those exclusions to income and give you more of a more clear recommendation. Oh, and the other thing, we didn't talk about that Brady actually has an update on the process piece for the Rules Committee. Brady, do you want to talk about that right now? Because that can impact what we move up or not. Brady, are you on?
Yeah, I mean, so I thought we'd talk about it when we're actually talking about the guidelines change, but I can preview that now, certainly. So just as some background, when we started this committee back in the early part of the year, we did some analysis on how constrained we are and what needs to be in rules, what needs to be in guidelines. And the short, purely legal answer then was that the State Bar is not subject to the Administrative Procedures Act, so that we're not subject to those very strict guidelines in terms of what needs to go into regulation that goes out for public comment and what can be in a policy or a guideline or some other source of law. And so at that time, we didn't understand there to be any desire to move from the status quo, which is that we have these State Bar rules, which are passed by the board after going out for public comment, and our guidelines, which are the eligibility guidelines and the financial standards, I think, are the main ones. However, there's been some more talk with leadership, and I think that there is a desire to bring the State Bar practice more in line with the rest of the state, and that would involve, rather than having separate rules and then guidelines, which go into more depth, basically have the rules say everything that we need to say. So that will result in rules that are somewhat longer, but it will arguably be a little bit more user-friendly because there will be one body of rules and regulations that you look at rather than multiple documents. So I think that doesn't necessarily change anything that we're doing substantively, but at some point in this process, what we might do is sort of go through our existing guidelines, figure out what needs to be moved into the State Bar rules so that we have one place that we can look for all of our policies.
And so Brady has offered that he would help us kind of figure out the transition from moving the guidelines are actually in fact rules into a formal State Bar rule. But just to answer your question, Judge Sutherland, I think if there's pieces of recommendations that are self-contained that we'd like to move out of process instead of waiting until the end, then we can certainly do that. That is definitely within the authority of this committee to make that recommendation to the commission, and then staff would just elevate that to the Board of Trustees for approval.
Did we already do that in the spring with one thing with the audit?
We didn't. We thought the audit was self-contained, and then through discussion, the committee decided to wait because they wanted to revisit that audit in the context of law schools and the context of some of the other financial pieces. Yeah. Rich, do you have a comment? I see your hand raised.
Yeah, it's in line with Judge Seligman's comment, and that is in anticipation of making a proposal to amend the statute. Would we be able, through basically our regulations, to put into effect, more or less on a trial basis, some of these changes that would be included ultimately in an amendment, so that when we propose this to the legislature, we can in fact reasonably predict the anticipated consequences of the amendment?
I guess I'm not quite understanding. Are you talking about the what Judge Seligman was referring to, the non-statutory recommendations, that we could move those up without an official rule change?
Well, this is a tandem idea, and I think that it's linked to what Judge Seligman is talking about, which is let's not delay. The statutory amendment could take much longer than we feel it's appropriate to wait. But what I'm suggesting to you is when you make a proposed statutory amendment, you're frequently asked, well, what are the consequences of this change going to be? If we have already put into effect rules and regulation changes that the commission and the trustees have approved, maybe some of those will enable us to predict for the legislature the ultimate outcome of the amendment that we're proposing. And I'm just wondering if there is a way to put into effect changes that would be included in the proposed amendment to the statute, so that we have some experience with boots on the ground of how that change will impact the community.
I'm having a hard time imagining what that would be, because the statute, we're only really looking for statutory changes where we need a statutory change in order to do what we want. So I'm having a hard time imagining what that would be.
Income threshold, for example. Could we act on our changes to income threshold without a statutory change? I think the answer to that is yes.
Yes. No. So, right. No, well, we can the exceptions, right? So I think that's why I'm coming back to Judge Seligman's point. Like, if the committee feels like that's a self-contained recommendation, it wouldn't impact other issues that we're looking into, then we can take that out of process all the way up to the Board of Trustees, and that can go into effect a lot sooner.
That's the idea, so that we can collect at it to demonstrate this is not going to cause a wholesale change in the way we function.
Yes, and I do think that the income exclusion piece, and some clarity around that I let us look at it and see if there are other implications. But off the top of my head, I feel like that may be an area that's self-contained that would give programs clarity, and it could go into effect quicker. That would help programs out.
Thanks.
Okay, great. So I believe we're on the next agenda item.
Did James have a question at 11:36, or we already got to that one? Thank you.
I'm sorry, I don't see it. Dan, who?
I saw some notes in the chat function, but it looks like James's question was 20 minutes ago. So that must have just been, we already got to it.
Juan, I can share my screen.
Okay, great. Thank you, Crystal. Oh, sorry. Yes, the motion did carry, Debbie. The motion was passed.
Okay, great. Just wanted to make sure everyone can see the PowerPoint. I'm unable to see faces, so I'll just carry on. So this is agenda item 4B, the primary purpose requirement for qualified legal services projects. Members for this working group included Corey Friedman, Rich Reines, as well as Judge Seligman. I just wanted to provide some updates from the March 6th Rules Committee meeting in which this issue was previewed. Just to briefly go over the governing authorities regarding primary purpose for QLSPs, we have the Business and Professions Code section 6213, specifically section A1, which indicates that all QLSPs must be a nonprofit project incorporated and operated exclusively in California that provides as its primary purpose and function legal services without charge to indigent persons and has quality control procedures approved by the State Bar of California. Just to note, primary purpose is actually not statutorily defined under this the BNP code. Therefore, the State Bar utilizes a quantitative test and references are found in State Bar Rule 3.671, as well as legal services, the eligibility guidelines as 2.3.5, which references a 75% presumption threshold of qualified expenditures, as well as in any other means tests. All right, in terms of the issue at hand, just to provide some context, the working group met on August 31st to discuss the primary purpose requirement for QLSPs. During that discussion, they did decide to focus on primary purpose as it relates to QLSPs. The State Bar rule does cover support centers and law school clinics, but those have other issues down the line with codification and will be discussed separately. Three main issues were identified in terms of the primary purpose requirement for QLSPs. The first being whether the commission should codify current office practice using a QLSP's expenditures from its prior fiscal year, according to 3.671 to determine primary purpose. The second was whether the 75% of qualified presumption for satisfying primary purpose requirements should be changed. And the third issue was whether the commission should retain discretion to find QLSPs eligible by any other means under State Bar Rule 3.671C. I'll be talking about each issue individually, as well as reflecting the legal aid community feedback that we received on October 4th. So the first issue is regarding the fiscal year for qualified expenditures calculations. So currently the State Bar rule requires an organization's proposed budget for the coming grant year, as well as the organization's expenditures in its most recent fiscal year to demonstrate primary purpose. Current office practice has been to utilize the expenditures from the prior year to determine the primary purpose and not necessarily the proposed budget, which leads to the working group's recommendation listed in option 1, which is to delete reference to utilizing that budget for the upcoming grant year. Reasons being is because we do request that QLSPs submit an audit or financial review, and it's a little bit more I guess more confirmed with those amounts because it is an audited or financial review. So this option 1 was the working group's preliminary recommendation. The legal aid community is also in support of this option and no additional comments were provided. Option 2, which you'll see through each of the issues, was no change to existing governing authorities, which wasn't the preliminary recommendation. And again, it didn't seem to be that the legal aid community was in support of option 2. Just wanted to pause here to see if there were any questions. Okay, great. I'm going to be moving out of order. This is the third issue that I identified earlier. This was the commission discretion regarding the any other means test. So under State Bar Rule 3.671 and eligibility guideline 2.3.5, it gives the commission the discretion to find organizations that do not meet the 75% tests as eligible if they demonstrate primary purpose by other means. This led to the working group's preliminary recommendation to update the governing authorities to further include guidance. There was there was a strong indication from the working group that maintaining discretion was important, even if the primary presumption were to be lowered, which I'll talk about after this. Similarly, the legal aid community that we received, feedback we received was also in support of this option with no additional comments. Okay, finally, the third issue, which I took out of order because there was a little bit more discussion and feedback regarding this, was the 75% qualified expenditure threshold for the primary purpose presumption. So according to State Bar Rule 3.671A and eligibility guidelines 2.3.5, QLSPs are presumed to meet primary purpose if 75% or more of its budget and expenditures is designated to provide free legal services. The working group had two recommendations, with the preliminary recommendation being option 1, which was to lower the presumption percentage. There is current office practice that the commission has approved QLSPs who report about 50 to 75% range as meeting this presumption, and there's discussion of codifying that practice. Generally, the community was in support of this option with the following two caveats. First off, the recommended percentage, or the range the working group looked at, was 51 to 60%, and the community had indicated that 52% might be potentially too low for the commission to publish and to codify. They also raised the issue that the definition of civil legal services, which is an upcoming codification issue, might potentially impact qualified expenditures. For example, QLSPs that offer holistic services, social work, high cap, etc. Should the definition of civil legal services be changed, that would also have an impact on the qualified expenditures, as in some instances, those are considered non-qualifying activities. So I wanted to pause here for some discussion, or if there were any comments regarding this issue. Okay. Great. So this is just a recap of the preliminary recommendations. Again, these are option 1s, and all of those options presented. The first is to codify office practice by deleting reference to calculating primary purpose based on budget information for the coming grant year. Codify practice by lowering the primary purpose threshold with the percentage to be determined, as well as maintaining commission discretion regarding the any other means tests, and that the commission would be including language to note reasons why, when and why this test would be used. As mentioned, while the legal aid community is in support of all the recommendations, in anticipation of the upcoming discussions regarding the definition of civil legal services and the impact that would have on primary purpose, qualified expenditures, and these related issues, the working group felt that it would be in the best interest of the QLSPs to keep all recommendations as tentative until all those discussions are held. So that brings me to the end of the update regarding this issue. Were there any other questions? Okay. Great.
Are there any other comments from any of the other working group members? And Crystal, we don't need to take a vote, right? Because everything is tentative right now.
It's all tentative. Yeah, it's more of an update as to what the working group has been working on. Okay. Yeah.
Okay, great. So we're at noon. If everybody can hold on, we can power through. I think we have about another. The next two agenda items should be pretty quick. A half an hour at most. If people are tired, we can also take a break. But we want to just power through and just finish. Take a 5-minute break. Okay, let's take a 5-minute break then. Let's come back at how about we just come back at 12:10? A little bit more than 5 minutes. Okay, great. Thank you.
it's interesting to me how uncontroversial that second discussion is compared to how much discussion and controversy and extra research is needed for that first memo. Thank
Yeah,
you for
which
the
is
bio break, by the way.
oh no, of course. But yeah, it's interesting because when we first set out, we thought that the primary purpose one, because it being primary purpose would be, I don't know, controversial is the right word, but yeah, more up for debate. But
Well, that's what you get for putting an academic on it. We always want more data.
no, it's good. That's why we need you on this committee, Jim.
Jim, I think your points were just especially helpful because I think a lot of organizations may think about how it may impact them if a major change is made, but they don't really think about the statewide impact. And so those points are really helpful.
Yeah.
Well, as a sociologist, I would prefer the median income, the AMI. I mean, that really reflects poverty because you got to include the cost of housing.
Yeah.
I'm just afraid it would really radically shift the money from rural areas to urban areas.
Yeah.
Although we could, that's an empirical question. I mean, we could run the numbers and see if it really does that.
Mm-hmm. Yeah, I think we run the numbers and just see, and then like Judge Seligman was saying, maybe we decouple it because in our minds we've always coupled it together because that's how the formula is run now, but we don't need to. So we'll see. So Dan, I have 1211.
Yes, I have 1212.
Okay, great. And Amin, I see Amin's back too, so that's great.
Yep, I'm back. Can you guys hear me okay?
Yes. Yes.
Did you want to make a vote on that last the vote that passed? We missed you.
You can count me in favor.
Thank you. I just didn't like an empty box sitting there.
Okay, great. So we can reconvene. Amin, is that okay? Should we reconvene now?
Yes.
And I could do roll call vote really quick so we have it for the record.
Great.
A minute to pull up the roll call. Okay.
Pull that up myself. Hold on a second.
Okay. Are you ready, Dan?
Yes.
Okay, great. Amin?
Present.
Corey? Zahira?
Here.
Zahira? Okay, great. Professor Meeker?
Here.
Kim Savage?
Yes, here.
Judge Seligman?
Here.
Great. So we have everyone back.
Thank you. Good.
Okay. I'm having connectivity issues. So Erica or Crystal, would you mind sharing the PowerPoint slide?
Sure.
And Erica, we're on your section for your working group.
So the next topic is the definition of civil legal services. And this working group is comprised of Amin, Kim Savage, and Eric Iskin. This update will be fairly brief because we're still just kind of in the initial phases. But the goal is to potentially revise the State Bar rule to further clarify the meaning or the scope of civil legal services. The current State Bar rule is fairly vague, and kind of given how civil legal services have evolved over time, it felt appropriate to kind of look at the definition and see if an update was necessary. So what we're currently working on, and we'll continue to work on through the end of the year, is researching the issue. So we're reviewing the current office practice, the treatment of things like the incorporation of social work into legal services and how that's been treated both by staff and the commission in the past and currently, looking at ethics opinions and consulting other relevant standards like the Legal Services Corporation's regulations and the American Bar Association standards for the provision of civil legal aid. What we would hope to move on to next is starting next month to hold some focus groups based on the questions that have already been identified with things like social work, high cap, housing counseling, and to get some feedback from legal aid community to just get more data and understanding about how these services fit into civil legal aid. And then after holding those groups, moving on in early January or in early 2021 to holding more focus groups based on other areas that are identified. And then the next phase would be to work on developing actual revisions or proposed revisions to the rule. One thing that's worth mentioning is that the American Bar Association is actually revisiting its standards for the provision of civil legal aid. They're starting that process now, and my understanding the last time we received an update was that they were going to attempt to move on some proposals early in 2021. So we will try to stay updated on that to ensure that any proposals are sort of consistent or with what's coming from the ABA.
Erica, can I just add also, so this is a tentative schedule, and it is fairly ambitious in that we want to hold some of the focus groups. So, depending on feedback from the community, we may need to move that back a little bit more. We're sending out a lot of surveys from from Rules Committee as well as from just the general office, and so we don't want to overstretch programs to feel like they need to dive into this. These are big subjects, so we want to give them ample opportunity. Now that we're moving towards the end of the year, we'll get a gauge from the community whether they'll feel overstretched if we engage them now. But we will try to stick with this if the community is open. If not, then we may need to move this back a little bit more.
How are you defining focus groups?
Well, Erica and I kind of talked about some of the hot topic issue areas. So, and she mentioned right now we might look into doing a focus group around social workers, maybe high cap, maybe legislative work. And then in terms of focus group, that the composition, we're hoping to have some representative of the commission, some representative of programs that do that particular type of work, and perhaps even also looking out externally if the issue warrants it. For example, we might have a focus group on housing counseling work. And in that case, unless we can find, say, an organization that has an actual housing counselor on staff, and I think there are, we also may want to look outside of the IOLTA community and invite an organization that primarily staffs, has housing counselors as staff. So I think they're going to look a little bit different, Jim, depending on the topic.
Okay, I was just wondering, I know I brought this up briefly at one of the last commission meetings on the issue of expungement. I was shot down pretty quickly by a judge, but I still think that's an important area, especially since other areas won't cover the cost of that. I mean, It's not, defense attorneys aren't compensated for covering that. And yet there's a lot of people in the poverty community, they can't qualify for certain things because they have a record. They need to get rid of the record.
So that particular issue, we've been in conversation with Selena at LAC on how to deal with this. And so, Selena, I don't know if you want to provide an update on how you're going to be reaching out to see if there's a bit more feedback from the community, because I don't know if there's consensus right now in the community in terms of how to deal with expungement.
We're going to run a little bit of additional gathering parallel to this process. So LAC has we regularly gather the directors of litigation and advocacy a couple times a year, and we hold conference calls and Zoom meetings throughout the year. And so we're going to raise the issue of expungement to find out how organizations are doing the work. I think that state bar staff probably is the most knowledgeable about how organizations are already reporting it, but we want to find out if organizations were not clear whether or not they could report it, how to track it, how to count it, and get a sense of if organizations are doing the work that they had not yet told the bar about because they're covering it with other funds. So we'll be doing some research, but just trying to get a sense of what organizations think and how they think of expungement within the way that they provide their services.
I don't see any other comments, Erica. Okay, we'll turn it back to you, Erica.
That was all I had.
Oh, okay, okay, great. So
Do you
we're
want me-
almost, we don't need to vote on anything, right?
No, but do you want me to keep running the PowerPoint for you?
Yeah, do you mind? I just have that one last slide. So this is just the last agenda item, and it's just really, we're going to do a really short, very short preview of the next item on for the January Rules Committee meeting. So this working group will be Zahira, Rich, Eric, and Erica. So Rich and Erica are not on the Rules Committee, but they're part of the commission, obviously. So I will be reaching out to the three of them very shortly to have a working group call to have a project plan. Next slide, please. Originally on the work plan, this topic, fiscal issues, covers a lot of subtopics. So in looking at it, we don't think we're going to be able to dive into every single one. So our proposal will be to deal and I've indicated on the slide here, was pass-through funds, exchange funds, out-of-county determination, carryover, and indirect costs. But to save the revisions to the purchase of real property, the entire standards of financial management, and how to calculate IOLTA formula until later in the process. But I'll go through each one of them right now. So pass-through funds. We know this has been an ongoing kind of discussion with the state bar. We know that this definition really needs to be firmed up. Earlier this year, there was a memo that was presented from staff to the commission because our proposal was to take this particular topic out of order. We had a lot of discussion during that commission meeting, and that definition that staff had proposed, there were deficiencies to it. So the commission did express, it gave us a directive to go back and work on that definition so that it would get closer to what we intend to do. So we want to deal with this at this juncture now for the January meeting. At the eligibility and budget review committee meetings this past cycle, the issue of pass-through came up. It was a live issue because there were a number of programs that had very large pass-through funds, but because we also didn't have a workable definition, we accepted their application of our current definition of pass-through funds in the application. But because some of them, some of the pass-through funds were such a large percentage of the overall total corporate expenditures, the eligibility committee meeting made a request that the rules committee meeting really dive deeper into it and send out a survey to the community to gather more information. So we will be moving into this phase of putting together a survey to send out not just to the programs that have passed through that they've reported on the application, but generally to the entire community, because there might be instances where an organization has passed through funds but actually didn't report it on their application. So we wanted to just survey the entire community and get some more data points, and hopefully we'll be able to bring to you in January a recommendation from the working group of a more workable definition. The next issue on the list is exchange funds. So exchange funds are a little bit related to pass-through funds. There are no governing authorities in terms of exchange funds. And what exchange funds are, so part of our annual IOLTA and EF application is we require both QSPs and support centers to report funds that they're exchanging with other IOLTA grantees. And that comes up most commonly when I'll give you an example. An organization receives a grant from the city or the county, and they're sub-granting to other organizations, and some of them are IOLTA programs. Who gets to count those expenditures and that work? We have a default kind of rule, and that if it's the organization that's kind of the lead grantee, they get to count those expenditures. And then the ones that are being the sub-grantees don't get to count it. However, that's just the default rule. If the MOU says something differently, and there's a different kind of understanding between the organizations, then we let the other organization. And the only reason we're just trying so that those funds are not being double counted. So if there's $500,000 that's being, distributed, we don't want one program to count it and another program to count it, and that would be kind of double counting of our. We just want those qualified expenditures to be counted one way. It's a source of confusion every year amongst programs, and it's very tedious for staff. So we need to be able to kind of really clarify what gets counted and what not through a state bar rule. The third issue for fiscal issues is out of county determinations. So right now, as you all know, for qualified legal services projects, they get to apply for an allocation per county. However, there are instances where QSPs take on work in counties in which they're not applying for an allocation in, and this is for a variety of reasons. Sometimes they're pursuing impact litigation in another state, in another county that they don't typically do. They're only there, with that piece of litigation for a few years. They don't want to apply because of that. It's temporary. They don't want to apply for an allocation in that particular county. So that's one example. Another kind of common example is that sometimes because if they're applying for multiple counties, it's very difficult for them to keep track. So if the expenditures are very low in a certain county, it might not be worth their time. So our office has kind of flip-flopped in our advice to QSPs and what they can count and can't count. I think historically we've said to programs that if you're not receiving an allocation in a particular county, you can't count those expenditures anywhere. In more recent years, we've been more generous, and we've said even though you're not receiving an allocation in those counties, you can take back those expenditures back to your home county. We just need some clarity from the commission how you want staff to deal with this, and then we need to be able to communicate it to programs, because right now we're more generous and we let counties bring it back, and count it in their overall qualified expenditures reporting. But not all programs know that they're able to do this, so we just need some clarity around this for programs. Carryover and budget modifications. So as you all know, with the stakeholder working group process in 2018, this was an area that was revisited with a pretty heavy discussion in terms of what are the thresholds of carryover and budget modification, and who has kind of discretion to approve the carryover and budget modification requests. There was a recommendation from State Bar staff that perhaps carryover and budget modifications should be approved at the staff level and not at the commission level, because it seemed to be a bit more administrative. However, the commission and the working group at that time believed that the commission should still have some oversight responsibility over carryover and budget modifications. So what we landed on, the recommendation was that anything below 10% for carryover budget modification requests, programs can self-approve, self-executing. They don't need to make a request to the State Bar. Between 10 and 25%, State Bar staff would have authority to approve, and anything above 25% would go to the commission. That policy change, it lives in what we call a functional matrix. There's not a State Bar rule that's carved out for that. It's very difficult to find, and we all know where it lives because we've gone through the stakeholder working group process. So this is definitely a rule that not only should we revisit, but if we want to keep with that status quo, we have to pull it up to a State Bar rule so it's more obvious for programs that that's the existing rule. And then the last issue that we're going to deal with for January is indirect costs. So we get the question a lot from programs, is there a cap on indirect costs? And right now, currently, there's not a cap on indirect costs. However, in our application, we have suggested percentages for personnel, non-personnel, as well as program and admin. And those suggested percentages are 25%, 75%. So at least 75% of programs' budget needs to be towards personnel, and at least 75% of a program's budget needs to go towards program. Those are just suggested percentages, and if a program deviates from that, we elevate it to the commission. But though that's just a practice that's clear in the application, but not codified anywhere. So we just need to decide whether we want to keep with those percentages.
Oh, did we lose you there, Duan? Duan will be back with us in just a moment, I'm sure. Are other members of the team working on this able to?
Okay. I'm sorry. Can you hear me now?
We've got an echo.
I'm sorry. Can you hear me now?
Yes.
Hello. Can you hear me now?
Yes.
Okay. I apologize. I'm just having a lot of connectivity issues today. I don't know if you caught the last part. So we need to just investigate to see whether to codify those suggested percentages or move towards the language of indirect costs and non-indirect costs. And then we'll save the other issues for later in the codification process. And that's all we have for the agenda today. I don't know if there are preliminary comments or questions on any of these topics. No? Amin, do you have any last words?
I did want to raise one question to the folks who've been on their working groups, who've been meeting and having and sort of moving forward with those discussions, and just to kind of see, this was a path we decided to take early on to try to split up the work and move these discussions along in an efficient way. And I wanted to see if anybody had any thoughts on how that progress is going, what they think of the working group process, and if they think that this is something that, is there any modifications or changes that we should consider to that process specifically?
This is Rich. I uttered this before. I'm not sure at one of these meetings, but I'm somewhat troubled by the notification, the idea of codification. In a sense, it's resting on the assumption that staff might not be reasonable under circumstances that require flexibility. And my experience in all my years on the commission is that staff has bent over backwards to be reasonable and transparent. I understand that there have been questions about transparency. Situations presented by all QLSPs and by those who would be grantees and have been turned down in the past. Those situations vary greatly, and to have flexibility is a virtue. And if you believe, as I do, that the staff uniformly does a reasonable job trying to codify everything precisely and anticipate all of the possible nuances that may be presented, I think is a somewhat impossible task and may backfire from time to time. That's my only comment about this. Otherwise, I think what we're doing is very worthwhile.
Thank you, Rachel. I think I completely agree with you. And I think part of especially early on when we're having these discussions, I think the view that I've taken, and I think that I share with others, is, this staff has been flexible and they've done an excellent job of carrying this through, but it sounds like there are tension points in a number of different ways where either they need a little bit more cover or guidance to be able to have that flexibility and feel like it's still operating within the context of the commission, or there's just a split of kind of approach that needs a bit more clarity. And I think keeping in mind the need for flexibility in this certainly has been something that I think many of us have felt is important to maintain within the context of this. And I do want to say thank you to the staff for all the incredible work that they're putting into this, because it's one thing to go through this process and on a day-to-day basis to do all of the work that they do without a bit of kind of guidance on where things may fall, and it's another thing to kind of create the rules or work on something that addresses what rules are going to be applicable, and give us guidance and give us a path towards clarifying that as well. So I think it's a pretty significant task, but I completely agree with what you said, what you're saying about where we end up at the end of it. Or if anybody else has any other comments, I guess the main question that I'm curious about is if, from a kind of a logistics standpoint, if this working group process is working out in terms of being able to meet, being able to have a productive discussion and those kinds of things, especially considering, the inability for us to get in the same room together to have these discussions.
Amin Zahira has her hand raised.
Okay, go ahead.
Thank you. And thank you for the question. The working group that I'm part of will be meeting soon, so I can't comment necessarily on how the breakouts have worked. This has been an incredibly informative presentation, so I've really appreciated all of the work that people have been doing to kind of move the work forward. I just wanted to sort of just briefly comment on one of the earlier points, and just to share that, I wasn't part of the commission when this particular committee was formed, and from everything I've observed, staff has been amazing in terms of how flexible and helpful they've been to organizations. I do think that each organization has a different level of expertise when it comes to applying for funding. And some organizations don't actually know that you can pick up the phone and call and ask questions. And so I think that the more you have some of this information down on paper, especially for those organizations that have staff that may not be constantly in a process of applying for funding, it just provides a playing field for them that gives them a little bit more access. So I would just say that, and I really appreciate the thoughtfulness and the effort to kind of go through that task, and in order to ensure that some of these pieces are really clear for people, even though staff has done such an amazing job, and hopefully will also alleviate some of the time that the team has to take to kind of go through some of the pieces with organizations again and again, although I know that you always do it beautifully and graciously. So thank you.
I think unless there are any other comments from folks, that was all I had, and I think that closes out our agenda.
We're up to item 5, adjourn.
Great.
Do we need a motion?
I don't believe so, right, Dan? We don't need a motion to adjourn.
I never see one in the lists. I believe that we can do it by acclamation. Is that the word? Or
just click off is what you do.
Yeah.
That's the technical term. Thank you.
Okay. Well, thank you, everyone.
Thank you, everyone.
Thank you very much.
Yeah.
Meeting is adjourned at 12:40.